students of the AP JCJ 2023, please read what I posted on the screen so that I could know that you are with me, I am with you, and both are traveling the same boat to reach to the destination. Quick.
Welcome to the aspirants of AP JCJ-2023-ST-Juvenile Justice within the parenthesis Care and Protection of Children Act 2015, multiple choice questions, virtual class on 3rd January 2023. Juvenile Justice, Professor Dr. Mohammed Saheb Hussain, Professor of Law, St. Augustine University of Tanzania, Mwanza, Tanzania.
Thank you very much. Okay, now without wasting the time, let me be ready for that one. The first question. Juvenile Justice within parenthesis Care and Protection of Children Act 2015, Act number dash, option A, 1 of 2015, B, 1 of 2016, C, 2 of 2015, D, 2 of 2016. It's a common question generally the people are going to ask in the examination, in the test. Shoot. Participants, your silence will kill me.
2 of 2015, sir.
Repeat.
Option C, 2 of 2015.
WRONG. Somebody using the music. WRONG wrong. C answer is. Second option.
Sir, option D, 2 of
Option D is the right answer. Act number 2 of 2016 is the right answer for the first question. Anyone can unmute and read the second question?
How many chapters dash and how many sections dash are there in Juvenile Justice Act? Option A, 9 chapters and 112 sections. Option B, 11 chapters and 113 sections. Option C, 10 chapters and 112 sections. Option D, 10 chapters and 113 sections.
Which one is the correct answer among the ABCD? Yes.
Sir, option C, 10 chapters and 112 sections.
Repeat.
Option C, 10 chapters and 112 sections.
You are right. It is 10 chapters and 112 sections. For instance, see, I will drag it to down. See how many sections you could see? 112. And regarding the chapters are concerned, I will show you here. It is okay. Some sound. Mute it. I am getting the sound. See, this is the 9th chapter. This is the 10th chapter. Is it clear?
Yes, sir.
So now switch on to go on to our original point. Yes. Third question. Match the following chapters from part A and the explanations or details in part B. Part A chapters, chapter 9, chapter 8, chapter 7, chapter 6. In part B, A, rehabilitation and social reintegration. B, procedure in relation to children in need of care and protection. C, other offenses against children. D, adoption. Options. Option A 1C 2B 3D 4A. Option B 1B 2D 3C 4A. Option C 1A 2D 3C 4B. Option D 1C 2D 3A 4B. Which is the correct option?
And option B, sir.
WRONG.
Oh,
Scroll down, sir. Please scroll down, sir.
Yeah, because already I have given. Scroll down, it is there. Up means this is up. 1, 2, 3, 4 up. Part A, part B. Options, only D option is down. Scroll down means come down. The right option is option D. Feedback, you can see. D 1C 2D 3A 4B. Chapter 9 Other Offences Against the Children. Chapter 8 Adoption. Chapter 7 Rehabilitation and Social Relations. And Chapter 6 Procedure in Relation to Children in Need of Care and Protection. Is it clear?
Sir.
Now, fourth question. Anyone can unmute and read.
in this JJ Act, how many modules have seen the dash enshrined in the JJ Act 2015? Option A 12 principles, option B 14 principles, option C 16 principles, option D 18 principles.
There are certain principles are enshrined in the Juvenile Justice Act of 2015. How many principles? Among the ABCD. Anyone?
14 principles. 14B.
WRONG. Second option.
Sir, B 18.
WRONG. The right option is C. 16 principles are enshrined in the Juvenile Justice Act of 2015. Fifth question. Which statement is correct statement? A. It replaced the Indian juvenile delinquency law and allows for the juvenile in conflict with the law in the age group of 16 to 18 involved in the heinous offences to be tried as adults. B. It replaced the Juvenile Justice Care and Protection Children Act 2000 and allows for the juvenile in conflict with the law in the age group of 16-18 involved in the heinous offences to be tried as adults. C. It replaced the Indian Juvenile Delinquency Law, Juvenile Justice within parenthesis Care and Protection of Children Act 2000 and allows for the juvenile in conflict with the law in the age group of 16-18 involved in the offences to be tried as adults. D. It replaced the Indian Juvenile Delinquency Law, Juvenile Justice within parenthesis Care and Protection of Children Act 2000 and allows for the juvenile in conflict with the law in the age group of 16-18 involved in the heinous offences to be tried as adult. Now, which statement is the correct statement among the four? A, B, C, D. Yes? Of course, A is correct. But I mentioned only juvenile delinquency law, only one. Of course, B is also correct because I mentioned Juvenile Justice Care and Protection of Children Act 2000. But in the C, I mentioned the both, but I missed something there. What is that? See, I mentioned both the acts here, but when you say heinous offenses is there, and here heinous offenses is there, but here I missed it. That means
The option D is right answer.
this is also wrong, this is also wrong, this is also wrong. So right answer is
Option D.
option D is the right answer because the JJ Act 2015, it replaced the Indian Juvenile Delinquency Law, that is the Juvenile Justice, Care and Protection of Children Act 2000, and arose from the juvenile conflict with in the group of 16-18 and heinous offenses be tried as an adult. So the D is the correct option. Is it clear?
Yes, sir.
So sixth question. The Act also sought to create a universally accessible adoption law for the India overtaking the dash that is applicable to the Hindus, Buddhists, Jains and Sikhs within parentheses. Which option is correct option? Number 1, Hindu Adoption and Maintenance Act. 2, Hindu Succession Act. 3, Indian Succession Act. Options A 1, B 1 plus 2, C 1 plus 3, D 1 plus 2 plus 3.
Sir, option B 1 plus 2.
WRONG.
1 plus 3. Sir, option C 1 plus 3.
WRONG.
Option
Sir, option 1.
Option 1 is the right answer. It replaces, is overtaking the Hindu Adoption and Maintenance Act. That is the right answer. This Hindu Succession Act and Indian Succession Act, I concocted, I fabricated. Is it clear? Now the seventh question. This act also replaces the dash applicable to the Muslims, though not replacing them. A. Hindu Succession Act. B. Indian Succession Act. C. Special Marriage Act. D. Guardians and Wards Act.
Sir, option D, Guardians and Wards Act.
It is true. It is a Guardians and Wards Act because it is nowhere connected with the Hindu Succession Act, Muslim people. Of course, Indian Succession Act is there to a certain extent. The Special Marriage Act also be there to a certain extent, but the exact answer is this act, the above act, JJ Act 2015, replaces the Guardian and Wards Act is the appropriate answer. Anyone can unmute and read the 8th question?
This act came into force from option A 14 January 2016, option B 15 January 2015, option C 16 January 2016, and option D 15 January 2016.
The JJ Act 2015 came into force.
Sir, option A, 14 January 2016.
WRONG. Second option.
Sir, option C. Option C.
Sir, option B, sir, 15 January 2015. 26, sorry, option D, 15
Option
January
D is the right
2015.
answer. It is the 15 January 2016 it came into force. The JJ Act 2015. Feedback. The Act also sought to create the universally accessible adoption of law for India, overtaking the Hindu Adoption and Maintenance Act and applicable to Hindus and Buddhists, Jains and Sikhs, and the Guardian and Wards Act 1890 applicable to the Muslims, though not replacing them. The Act came into force 15 January 2016. The above, these things are replaced and we discussed there. And here I am giving the feedback. Yes, ninth question. Anyone can unmute and read the ninth question.
This
This
act
act
has
has
further been amended by the Juvenile Justice within the parenthesis Care and Protection of Children Amendment Act 2021, which have come into force from option A 1st September 2022, option B 2nd September 2022, option 3 3rd September 2022, option 4th September, option D 4th September 2022.
answer is A, sir. Option A.
Answer is A. It's the 1st September 2022. Which act? It's the 2021 Amendment Act, which came into force because it's the latest amendment to the 2015. Is it clear?
Sir.
Supplementary question. Which act it is? Act number. I did not mention the act number here. Or which amendment it is. Of course, it's the amendment of 2021. But there is the act number also. Supplementary question. Please try to see such a thing also. Okay, 10th question. Match the following chapter from part A and explanation are detailed in the part B. Part A, chapter 4, chapter 5, chapter 4, chapter 3, chapter 2. It is a descending order I made. Part B. A. Juvenile Justice Board. B. General Principle of Care and Protection of Children. C. Child Welfare Committee. D. Procedure in relation to children in conflict with the law. Options A, B, C, D. A. 1B, 2C, 3D, 4A. B. 1A, 2B, 3C, 4D. C. 1A, 2C, 3A, 4B. D. 1C, 3D, 2D, 3A, 4B. Which is the right option among the A, B, C, D? And in my yesterday class, I told you, this way also they can ask the questions based on Bare Act. Shoot. Option is
Sir, answer is D, sir.
answer
1C,
is
2D,
D.
3A, 4B.
1C, 2D, 3A, 4B is the right answer. Chapter 5, Child Welfare Committee. Chapter 4, Procedure in relation to children in conflict with the law. And chapter 3, it is the Juvenile Justice Board. And chapter 4, it is the General Principles of Care and Protection of Children. Is it clear? Say yes.
Sir.
Good. 11th question. Anyone can unmute and read the 11th question in sonorous voice. See, who read early, give the chance to other person. Sir, only 2 are reading, sir. Other people, please try. Your voice also recorded here. Participants, there are 8 participants including me. Ahmed, you read it.
In July 2014, Ministry of Women and Child Development said that they were preparing a new law which will allow 16 years old to be tried as adults. Option A Varun Gandhi, option B Priyanka Gandhi, option C Menaka Gandhi, option D Rahul Gandhi. Sorry, answer is option C Menaka Gandhi.
It is a Menaka Gandhi. She is a minister for what?
Women and Child Development.
Women and Child Development at the time. And what is the relation with the Indira Gandhi?
Daughter-in-law.
And whose wife she is?
Rajiv Gandhi.
Arun Gandhi.
sorry. Sanjay Gandhi.
Sanjay Gandhi. There is a one famous case law is there, Maneka Gandhi case law, which article deals.
Passport. Fundamental law.
Seizing of her passport.
Impounding the passport, fair trial should be done. Procedure should be followed. Article 21, it's based on it.
Yes.
And she is a founder for the animals protection.
Yes, sir.
Yes, 12th question. Like Chipko movement. Who did the Chipko movement? General knowledge question. Environmental law question. Is it not
Sundarlal
Sundarlal Bahuguna? Yes? Sir, we don't know.
Yes, sir. Yes, sir. Yes, sir. We heard, sir.
Okay, 12th question. A revamped juvenile justice bill was passed in the Lok Sabha on 7th May 2015. The new bill will allow the minors in the age group of 16 to 18 to be tried as adult if they commit dash crimes. A. Cowardly crimes. B. Dastardly crimes. C. Heinous crimes. D. Serious crimes.
Sir, option C, heinous crimes.
I read in the above options several times. I told you also I removed the heinous from there. Am I right?
Yes, sir.
So the right answer is heinous crimes. That is the right answer. 13th question. Dash on 8th August 2015 told Hindustan Times, I quote, we are civilized nation and if you become barbaric by twisting our own laws, then the enemy will succeed in destroying our social structure. We should not allow that, but we must condemn this move of sending the children to fight their war. Iron quote. Who said these words? Option A, Justice Bhuvaneshwar Prasad Sinha. Option B, Justice B.B. Gajendra Gadkar. Option C, Justice Sudhi Ranjan Das. Option D, Justice A.K. Sarkar.
Sir, pass.
Try, no matter, there is no minus marks. There is no minus marks. These words are said by Justice Sodhi Ranjan Das, and he used the such words in the 2015. 14th question. There are many positive in the 2015 Juvenile Justice Act. It was enacted to correct the deficiency in the previous legislation. Some of the important benefits of this act are: one is the false statement among the four. I made the four statement. One statement is false among the four regarding the positive side of the act. A. There is a clear distinction between children in dispute with the law and children in need of protection and care. B. It makes the registration of all children's homes mandatory, bringing in more transparency and efficiency in the system. C. It seeks to reduce the crime committed by the children between the age of 16 and 18. D. By including the provisions for the 16 to 18 years old to be tried like adults in case of heinous crimes, it provides justice to the victim of such crime. Among the A, B, C, D, one is a wrong statement. Which is the wrong statement among the A, B, C, D?
Sir, option A.
If I say option A, why it is wrong? Give the reason also. I know that it is option A is a false statement. There is a clear distinction between children.
Because
Yes.
children in dispute with the law.
What is the right wordings?
Ignorance of law can be the right word instead of dispute.
No, 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 no. I replaced the word dispute instead of conflict.
Okay.
Dispute is different, conflict is different. Can you tell me what is the difference between a conflict and a dispute? If you know, you should
Conflict
tell me.
can
If
be
not, you say pass on.
unknowingly, can happen unknowingly.
Say pass on, I will give the answer.
Pass.
See, there is a wife and husband. One is socialistic concept, another is capitalistic concept. So there is a conflict in the school of thought. Is it clear? And dispute comes
Yes.
between their land disputes, house disputes, succession disputes. These are the disputes among the land disputes, because they say land should be disputed among all because of the N.T. Ramarao amendment of the section. What is the amendment of section? That equal rights should be given in the inheritance, either the movable property or the immobile property or the ancestral property. Hindu Succession Act. Section
Equal rights.
Section 6.
Section 6. That is a dispute. It's not a conflict. Is it clear?
Yes, sir.
Yes, sir.
The legal system can be used over there. We don't say dispute. Conflict between the Indian legal system and Tanzania legal system. We don't say dispute, it's a conflict, because that's why I say private international law is a conflict of laws, not dispute of laws. Is it clear?
Yes, sir.
Okay, now I failed to make it out. The full form of NCRB. What is this NCRB full form?
National Crime Record Bureau.
Is it which type of the abbreviation it is? There are 4 types of the abbreviation I taught.
Initialism.
It is initialism because you are pronouncing the each letter NCRB. So it is the National Crime Records Bureau. Supplementary question. 15th question. Which one is wrong statement in JJ Act in the negative side of the JJ Act? A. Some opine that the treating minor between the 16 and 18 years differently is a violation of the Article 14 of the Constitution, which guarantees every citizen the right to equality. B. India ratified the UN Convention on the Right of the Child in 1992, that is called CRC. According to this convention, any individual below the age of 18 years is to be treated like a child. This is in contravention to the amendment law that gives provision for the treating 16 to 18 years old like adult. C. A mental assessment is to be made to assess whether a minor can be treated as an adult or not. However, this can be subjective and not entirely scientific. D. The argument to include the 16 to 18 years old minors in a special bracket which was based on the data from the NCRB. This data it itself is questioned by the many and also many of the cases were in the FIR stage under the preliminary proceedings only. So among the ABCD answer, which is the wrong statement here? One is the wrong statement here among the ABCD. I framed the question in such a way, in whatever the angle the questions are framed by the AP you are in a position to shoot them even though you don't know the answer.
Sir, answer option A.
Wrong. Everything is perfect in option A.
Option C, sir.
Yes, I appreciate option C is the answer. But tell me why it is the C is the wrong answer. You shooted very correctly. I appreciate. But you have to also give me the answer. Of course, in the JCJ, they don't ask you the detail. No, just you tick it enough. The answer here is
Because the age is not mentioned here.
no,
It
no,
can
no.
be
I said
supposed
a
to be
mental
between
assessment.
16.
It is not a mental assessment. It is a psychological assessment. Feedback is a psychological assessment is to be made to assess whether a minor can be treated as an adult or not. However, this can be subjective or not entirely the scientific. It is not the mental assessment, it is a psychological assessment. That is the appropriate word. Okay, now IPC, it says over there, a minor who is above the age of 7 years, below the 12 years, if his mental maturity is not over there, his act cannot be considered as an offense. Which section of the IPC says? Supplementary question. 7 to 12 years and will not reach to the maturity, then his offense is not said to be the offense. If I not be mistaken, it is a IPC 83 section. Please correct it if I am wrong. Is it clear?
Yes, sir.
Okay, now the 16th question. See here, in cases where a child has been accused of an offense that is punishable with the imprisonment for a fewer than 7 years, the investigation must be completed within 3 months from the lodging of the FIR, and the trial must be completed within 6 months from the filing of the charge sheet decided in the case of. It's a famous case law, it is there in the IPC plus JJ Act. I am hiding the case law name because I know that if I give the case law name, you will definitely will say. If I give the 4 case law names, you definitely click right case law.
It should be Nirbhaya case.
No, it is not a Nirbhaya case because Nirbhaya case deals about the 16 to 18. This is Sheila Barse and other versus Union of India others. It is a very famous case law where the dispute comes over there. The fewer than the 7 years would be there, whether it is said to be a crime or not. If it is a crime, then these are the frameworks are there within the 3 months and within the 6 months it should be completed. That is Sheila Barse and others versus Union of India and others. Now next case law. In this case, the Honorable Supreme Court held that juvenility of a person in conflict with the law has to be reckoned from the date of the offense and not from the date on which cognizance was taken by the magistrate decided in the case of. The date is more important. Reckoned from the date of the offense and not from the date on which the cognizance was taken. It is one of the famous case law, and this case is decided by the apex court of the country. Here I hided the case law. I know that definitely you will shoot the case law if I give the multiple choice questions. But I would like to see whether you know from the date of the offense is counted, not from the date of the cognizance. The name of the case law is Pratap Singh versus State of Jharkhand and others. In that case law, it is that from the date of the offense, not from the date of cognizance. Now, 18th question. The Supreme Court in the Juvenile Justice Act is a beneficial legislation and a technical plea like delay in making the claim of juvenility would not disable a person from making a claim under the Act, but the burden of proof for making out the prima facie case for directing an inquiry into the plea of juvenility rests on the person who makes such a claim decided in the case of. The burden of proof shifted to the person who claims that the boy or a girl is below the age of the 18 years. Or as per the section 83 of the IPC, if I not be mistaken, between the 7 to 12 years age, doesn't reach to the maturity, it is not amount to offense. So, the JJ Act is a beneficial legislation to benefit to whom? Benefit to whom?
Juvenile. 16
Juveniles
in the age.
and below the age of 18 years. So this is Jitendra Singh and Babu Singh versus and another versus state of AP. UP, Uttar Pradesh. Still we have the 5 minutes with us. See, today I am not giving the options to you. No. But I am giving only the what is held. This case was primarily related to the implementation of the Juvenile Justice Care and Protection of Children Act 2000 and Juvenile Justice Care Protection Act 2015 JJ. The court observed that the children are the future of our country and they must be looked after. So it issued a several direction to ensure the proper implementation of the JJ Act in 2015, in which case law there are many guidelines are given by the Supreme Court. Of course, Nirbhaya case law also given it. But I will also ask, what is the Nirbhaya case law? Name of the case law, Nirbhaya. Jyoti Singh versus. Please check it, whether I am right or not. But this case law is Sampurna Behura versus Union of India and others. They said regarding the 2000 JJ Act and JJ Act of 2015, the both are discussed over there. The another case law is this: the court held that for the determination of the age of a minor, a reference must be made to the Rule 12 of the Juvenile Justice Care and Protection Rules 2007. Furthermore, it is observed that even though the procedure mentioned under the aforesaid rule is meant only to determine the age of the child in conflict with the law, it can even be used for the determining the age of the child who is a victim of crime decided in the case of dash. I have given you the case law is Jarnail Singh versus State of Haryana. And 21 question, in this case the court held that where any of the documents mentioned in the Rule 12-3A-1-2-3 clauses of Juvenile Justice Care and Protection of Children's Rules 2007 are submitted in the support of the claim of juvenility, that there must be considered to be the conclusive proof of the date of birth of the accused. But if there is a doubt and the accused is taking a contradictory stand, then the court ordered an inquiry for the determination of the age of the accused. Such inquiry could be included a medical examination regarding the date of birth of the juvenile. A famous case law is there, that is the Parag Bhati juvenile through the legal guardian Srimati Rajni Bhati versus the state of Uttar Pradesh and others. Yes, now the supplementary question is Nirbhaya case in which year?
2012.
Yeah, appreciate. Who is the Nirbhaya? The victim name? I told you just before. If I not be mistaken,
Jyoti Singh.
Jyoti Singh. Am I right?
Yes, sir.
And it is there in Delhi. It is called the gang rape case. One of the accused is below the 18 years. He is roughly 17 years. That's why they changed the year of adult from 16 to 18. If they ask the question, in which year the age of an adult is mentioned 16 to 18, in which case law, then you can say the Nirbhaya case law. And of course, they don't ask the Nirbhaya case law, original title of the case law, because they want to keep it as a secret. Because they don't want to stigmatize the victim. Nirbhaya is still alive or died?
Died.
She is a graduate of what? Is it an engineer or pharmacist or nursing?
Law graduate.
Yes? Yes, of course, such questions will not be asked. But who defended the case? It's a lady. Am I right?
Yes, sir.
Even I heard also. Please, you check my earlier JCJ Telangana. I made very much clear in that discussion, and you hear and that's why I not repeating.
जनगणमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभाशिष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।